All right, we're going to read the BARBRI outline, and it's for evidence. I'm not going to go into each subpart, but the major groupings are general considerations, relevance, judicial notice, real evidence, which they have like authentication, and probably best evidence actually is in the documentary evidence section, testimonial evidence, and hearsay rule, seizure considerations, burdens of proof, presumptions, and relations between parties. So they always break it down in the funniest ways. So let's just jump right in. Sources of evidence law is at the beginning in the general consideration section. There are 3 sources of evidence law. 1, state common law and miscellaneous state statutes. 2, comprehensive state evidence codes. And 3, the federal rules of evidence. Exam tip: the federal rules govern on the multi-bar examination. Beware of answer choices stating the correct common law rule rather than the federal rule. 1, applicability of federal rules. The federal rules of evidence are generally applicable in all civil and criminal federal proceedings. However, except for rules relating to privilege, the federal rules of evidence do not apply in the court's determination on a preliminary question of fact governing admissibility. 2, grand jury proceedings, and 3, other miscellaneous proceedings, including those involving sentencing, extradition, bail, and probation. Part B in the general consideration section is threshold admissibility issues. Generally relevant evidence is admissible if it is competent. Under the federal rules, relevant evidence tends to prove probativeness, any fact of consequence to the action, materiality. Evidence is competent if it does not violate any exclusionary rule, for instance, the hearsay rule. So that's a new way to look at this. Relevance, just without all that extra reading, is relevant if it tends to prove any fact of consequence to the action. Under the federal rule, this is evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. And that's section 401. Just trying California to see if there's anything different. No evidence is admissible except relevant evidence is section 350. 351, except as otherwise provided by statute, all relevant evidence is admissible. Okay. Evidence means testimony, writings, material objects, and other things presented to the senses that are offered to prove the existence or non-existence of a fact. That's from section 150. of the CEC, the California Evidence Code. So I found that to be really interesting that like section 401 of the California Evidence Code does not give the definition of relevance. And I almost, if I'm not mistaken, believe that what I'm seeing here is that it's incorporated in the definition of evidence. And therefore, actually, in fact, the BARBRI outline is pretty close to the groupings within the California Evidence Code. So this might be easier to refer to once we get in sync. So back to relevancy as defined in the word evidence in the California Evidence Code, section 140. Evidence means testimony, writings, material objects, and other things presented to the senses that are offered to prove the existence or non-existence of a fact. All right. Threshold, no. So the next section is direct and circumstantial evidence. Direct evidence involves no inferences. It is testimony or real evidence that speaks to a material issue. In the case, circumstantial evidence is indirect and relies on inference. It is evidence of a subsidiary or collateral fact from which alone or in conjunction with other facts, the existence of the material issue can be inferred. Limited admissibility. Evidence may be admissible for one purpose but not another, or admissible against one party but not another. In these situations, the court must, upon timely request, restrict the evidence to its proper scope and instruct the jury accordingly. Therefore, the court may exclude the evidence entirely if it determines that, even with the limiting instruction, the probative value of the evidence with respect to the legitimate purpose would be substantially outweighed by danger of unfair prejudice with respect to its incompetent purpose. So the next section is relevance. Relevance questions should be approached in two steps. One, determine whether the evidence is relevant, tends to prove or disprove a material fact of consequence to the issue. Action. And if relevant, determine whether the evidence should nonetheless be excluded based on judicial discretion, which is, for example, probative value outweighed by prejudice, etc., or Section 2, public policy, insurance, and subsequent repairs. So determining relevance. Part A. Evidence is relevant if it has any tendency to make the existence of any fact of consequence to the determination of the action more probable or less probable than it would be without the evidence. So any tendency is what's highlighted there. There's this interesting table I'm seeing here. It actually is a 4-step process. So we read a 2-step process. Here, step 1 is the evidence relevant. Step 2, is there a proper foundation? For example, has the competency of the witness, the authenticity of the evidence, or the reliability of the scientific test been established? Step 3 is the evidence in the proper form. For example, questions are properly phrased, answers are within the requirements for lay and expert opinion, and documents comply with the best evidence rule. And step 4 is the evidence beyond the application of or within an exception to one of the following exclusionary rules: discretionary exclusion for prejudice, policy-based exclusions such as subsequent remedial measures and settlement negotiations and insurance, like we just said, plus privilege, hearsay, and actually parole evidence. And that would seem to me to be a disjunctive test, I believe. No, a conjunctive test, meaning that if everything there is met, then the evidence is admissible. If any one part of it is not met, it probably is not admissible unless it's incredibly probative in respect to the prejudicial nature of the evidence. So 1, as a general rule, must relate to time, event, person, and controversy. Generally, the evidence must relate to the time, event, or person involved in the present litigation. Otherwise, it does not